Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm studying professional responsibility and I'm studying the authorized disclosures. And in this video, I'll be going through Model Rule 1.6a and I'll be making another video going through the rest of the rule for you. And finally, I'll be talking about the difference of informed consent and implied authorization. So, Model Rule of Professional Conduct 1.6a. This is where I get my rule from, right here. It states that a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation. The next thing I'll be talking about is implied authorization. So, a lawyer may have implied authorization to carry out the representation, but there might be some express limitations that may apply here. Right now, I'd like to give you the difference between an informed consent and an implied authorization. So, informed consent versus implied authorization. Under the informed consent, there must be a discussion with the client and there must be express authority to disclose. And under implied authorization, it's at the discretion of the lawyer and a discussion is likely not needed. So in this video, I talked about disclosure and when it is okay. So disclosure is okay when the client gives informed consent and the lawyer is impliedly authorized. And implied authorization when they're appropriate to carry the representation. In my next video, I'll be talking about the exceptions to the confidentiality rule. Good luck studying. Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm studying professional responsibility and I'm going through the exceptions of the confidentiality rule. So I'll be going through the Model Rule of Professional Conduct 1.6b and I'll be talking about the optional disclosures, reasonableness standard, and I'll be talking about the 6 circumstances where confidentiality is not required. So, Model Rule of Professional Conduct 1.6b states that a lawyer may reveal information relating to the representation of the client to the extent the lawyer reasonably believes necessary in the following 6 instances that I'll be going through right here. And there are 6 exceptions to the confidentiality rule. The first one, to prevent a reasonable certain death or injury. The second one, to prevent crime reasonably certain to cause substantial injury where the lawyer's services are used. So you want to look at where the lawyer's services are used. And to mitigate a substantial injury from the client's harm and where the lawyer's services are also used. Next, legal advice about the lawyer's compliance with the ethics rules and dispute where the client and the lawyer, they are disputing together, and compliance with the law or the court order. So I'd actually really like to read the rule for you because right now I just gave a summary, but I didn't read every detail of the rule for you. But I really think this is a really important rule, and since my book is already falling apart and I brought it down here for you, I might as well read it. Part B states that a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary. 1. To prevent reasonable certain death or substantial bodily harm. 2. To prevent the client from committing a crime or a fraud that is reasonably certain to result in a substantial injury to the financial interest or property of another, and in furtherance of which the client has used or is using the lawyer's services. And 3. To prevent or mitigate or mitigate or rectify substantial injury to the financial interest or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud in furtherance of which the client has used the lawyer's services. And 4, to secure legal advice about the lawyer's compliance with these rules. And 5, to establish a claim or defense on behalf of a lawyer in a controversy between the lawyer and the client, to establish a defense to a criminal charge or civil claim against the lawyer based upon the conduct in which the client was involved. or to respond to the allegation in any proceeding concerning the lawyer's representation of the client, and 6, to comply with other law or court order, or 7, to detect and resolve conflict of interest arising from the lawyer's change of employment or from changes in the composition or ownership of a firm. And also, but only if the revealed information would not compromise the attorney-client privilege or otherwise prejudice the client. And finally, Part C states that a lawyer shall make reasonable effort to prevent inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of the client. So now that I went through the rules for you, I'm going to summarize everything I talked about. I'm sorry that it was a little long because I really wanted to read the rule for you. So in this video, I talked about disclosure of confidential information. It is okay when the lawyer reasonably believes to prevent death or injury, prevent crime, and substantial injury when it involves lawyer services to mitigate or rectify crime that caused substantial injury when it involved the lawyer's services. And also, disclosure of confidential information is okay when the lawyer reasonably believes ethics inquiry or lawyer-client dispute, and finally the court order. Okay, so now that I got to read all my rules for you, I would like to let you know that actually in no circumstance should the lawyer share the client's secrets. Like, I even asked the professor, what if the client comes to the lawyer and is, saying that he wants to do something illegal? Okay, no, the lawyer is under no duty to give out the client's information. So that's all there is to it. So when you're trying to answer an exam questions, just think to yourself that in no way can the lawyer disclose the information. So that's what you want to argue. On the bar, that's what I'm going to argue, and I'm really trying to help you, and I hope this helps. But then again, I'm just a law student and I'm just doing my best, and I didn't even get my midterm grades back, but I know enough that the lawyer must keep the client's secret. That's all there is to it. I really hope you enjoyed this video. Good luck.